Viewers, welcome back to the Personal Injury Law Show. Before the break, we were talking to Namh about the plight of migrant workers, especially people from Vietnam in this case. Namh, you've got a story of a couple of friends. Tell us the first one, how he was injured, didn't consult a lawyer, and he's gone back to work. Tell us a bit about that fellow.
About 10 years ago, my close friend was saying the story to me. His brother, he's working in the demolish company. He was using a chisel and somehow the chisel just fell off, it's flied off the handle and it hit his eye. He got injured badly. A few months later, I followed up with him, how's your brother go? And he replied, oh, my brother went back to work. Okay, your brother's supposed to have a big compensation from the company. How come he's going back to work?
And Namh, so he didn't consult a lawyer, didn't go to a lawyer?
I wasn't quite sure.
Okay.
But in that case, I would believe he did not do it.
Okay. Now, John, coming to you, he had rights, didn't he? No fault benefits, correct?
Exactly. He's got no fault benefits. He's got weekly payments. He should be, I think, off work a bit more than just 2 or 3 weeks when you've lost your eye, Tony. And also, there's an impairment benefit total loss claim.
Yeah, but John, it gets worse than that. And Namh, he obviously had no protective glasses.
Yes.
He was using machinery that probably didn't have any guards on it, or using equipment that wasn't properly explained to him. So your fellow has lost his sight and he's got nothing to show for it. And the worst part about it is, it could impact on his future in terms of work.
Oh, it will.
So that was 10 years ago, was it, Namh?
Yeah, about 2003, yeah, 10.
Okay. And I bet you he also doesn't know, viewers, that he's got time limits. He's got 6 years to sue. In some instances in work cover, John, you can get beyond the 6-year limit, can't you?
If you can show there's no prejudice, yes, you can.
Okay. Look, there's been a lot of cases that you've done where it's been more than 6 years and the claim's still been accepted, correct?
Exactly, exactly. Unfortunately, and this is what we're trying to get across to all migrant workers, that you have lump sum entitlements, particularly if the injury is not your fault. In losing an eye, that could easily be worth $200,000. So,
and if it impacts on his future work capacity, it could be a lot more than that.
Exactly, exactly.
So, Namh, you should say to your friend, get him to get some advice from a lawyer. You've got another story. Tell us the other story.
Another story was there's an elderly guy. He's about 65 or 70. He stood in the footpath. There's a not a hole, but you couldn't see the hole, but somehow it just fell off, and one his legs fell off. He got injured badly, and a friend was advised that he would claim from the council, get a big pay out of it, but he did not get anything.
Didn't get advice? Didn't go to a lawyer?
I didn't know, so he did not get anything out of it.
John, once again, very difficult area of law.
Exactly.
There's rules of misfeasance, non-feasance, the Road Management Act, so you need proper legal advice, correct?
Exactly. But at the same time, if the injury is not your fault and it's clear that in this instance
there's a third party,
there's a third party and someone would have been injured, you most likely have the right to sue.
That's exactly right.
And that's where we're trying to impress upon everyone. When you're injured, seek legal advice.
And Namh, is it fair to say that in both cases, both your friends that you're aware of probably didn't get properly looked after because of their English problems?
Yeah, he was an old man who couldn't speak English, so he was afraid of facing the problem. Too much time involved. That's why
from now on, no doubt, you'll give him advice and take him to a lawyer.
Yes.
I'm sure you will.
I will.
John, one of the things under the legislation, the Occupational Health and Safety Act, says that employers must put instructions on the walls in every language of every worker that works on a site, in a factory that is.
Exactly.
How important is that, John?
Well, it's very important, Tony. Workers, especially migrant workers, they need to be aware of the hazards in the workplace. What are the pitfalls? What are the dangers in this workplace? You could be working in a chemical factory. You need to be aware that you can't touch certain chemicals with your hands. Then there's other instances when you're working in a manufacturing factory. Don't go near that blade when you're working, and make sure the blade is covered by protection.
That's correct.
Some workers just don't know.
Exactly.
And if they're not explained by the employer, and this is where the legislation makes it clear, the onus is on the employer to explain it to the workers, not the other way around.
And Nam, you mentioned the first example of your friend that didn't report it to the employer, but the other thing that WorkSafe and OH&S laws say is that there should be signs up explaining how to lodge a claim.
Yeah.
In the workplace. Isn't that correct, John?
Exactly, Tony.
And that you've got to report a claim and things like that. John, there's another issue I want to raise. There's a lot of students here on visas and other workers on visas. Now, their visas say they can only work X number of hours. Let's say 20 hours a week. What happens if they're doing 30 hours a week and they get injured, John?
Yeah, initially it was a grey area, Tony, and a lot of workers were hesitant to make claims. But the law is quite clear. When you're injured in Victoria, you can make a claim, even if you've worked an extra 5 hours a week over your visa conditions. Particularly, and again, if you can show the injury was not your fault, you have common law entitlements, don't you, Tony?
That's exactly right.
Yeah.
And Nam, I bet you didn't know, you've got a lot of friends that are probably working more hours than they should, and they won't complain because they're scared they might lose their visa. Is that correct?
That's right.
So they will not lodge a claim because they think the extra few hours, the immigration department will throw them out.
Well, they think that they don't have the same right as the Australian citizen, so that's why they don't make a claim.
Tony, occupations such as taxi drivers, cleaners, those type of occupations, they're the ones that we want to try and press upon people that you do have rights if you're injured.
That's exactly right.
Particularly when the injury is not your own fault.
Look, this country is built on migrants. Over the years, we've had people come from Europe. Now we've got them coming from Asia. We've got them coming from Africa. So this episode is directed at everyone that comes in from all parts of the world. So please, if you get into trouble, get advice. The language barrier is there. Speak to an interpreter. Get taken to a lawyer. If you can't find an interpreter, no doubt the lawyer will organise one. Isn't that correct, John?
Exactly.
John, is there anything else you want to say before we wrap up?
Well, Tony, we've said this to all the viewers before. Facebook and Twitter, please, we want to hear your feedback. We want to hear what you've got to say, particularly injured workers and migrants that have been injured. Please give us your feedback. We enjoy the commentary.
We welcome it. Yes, yes. And Nam, I really want to thank you for coming on the show. I'll get you back another time in the future with more stories about your friends and family and other people like that. And viewers, I want to thank you for watching this show. Please stay tuned for future episodes and remember always to stay safe.